Item 8.
May please, your lordship. My lord, here in this case, my lord, we have to take the fee service. We have taken the fee service in
But
respect of
here,
the.
here today, one application is there for improvement.
My lord, my client is given me instruction that they wants to file it to oppose it, my lord, file an objection
What's
petition.
the,
Some time may be granted.
what the issue raised in the PIO?
My lord, issue, my lord, is that, my lord, there has been some incident in the school, my lord, in the Silchar school, and molestation of girl student. There has been some
That's
other
Against the
incidents, my lord.
format-
We want to
formation of the
stop that.
New committee.
No, we are not concerned with the constitution of new committee or not. That is another issue. But our issue is that this some people are involved with the my lord, with regard to molestation of girl students and the school management fund and anti-examination fund.
And they have been included, they have been inducted
They-
into the committee.
Yes, my lord. Yes, my lord. These applicant, they are the persons behind this.
Who are the?
My lord, the petition has been filed by the guardian society, my lord. They say, we are disputing it. We are some of the guardians. We have filed a title suit, my lord. Injunction petition is there, my lord. They have not responded, my lord. We are challenging the formation of the society, my lord. They have placed all misleading facts in this PIL, my lord. In fact, one writ petition is pending with the same prayer, my lord.
What is your objection? It's a
My
PIL.
objection,
Ultimately, it's a PIL.
my lord.
So we have to hear everybody.
Yes, my lord.
Not
Yes,
a
yes, my
personal, you're not,
Yes,
it's
my
not your personal,
Yes, my lord.
dispute or whatever it may be.
My
You
lord.
allow this petition.
My lord, even if, my lord, this title suit is declared against us, we are ready to face that, my lord.
And then the Municipal Super for consideration of the IA number so and so. Referred on behalf of the applicants with a prayer to increase them as party respondent in this, in the PIL number 35 of 2024. Stop. The, in the PIL number 35 of 2024, since the petitioners have raised issues regarding, the issue regarding induction of certain persons in the, what's the name of that committee?
My lord.
School Management Committee. What's the name of that
My lord,
committee?
Society of Guardians, this is the petitioner, my lord. Managing committee, my lord.
School Management and Development Committee of Silchar Collegiate
Yes,
School.
yes, my lord.
Of Silchar Collegiate School. And the applicants are applicants have filed this application stating that they are directly going to be affected with any order passed in this PIL, since at present they are the members of the said committee. Full stop. Taking into consideration the above fact and circumstances of the case, we deem it appropriate to allow this IA and direct the respondent, direct the petitioner to include the applicants as party respondent number
7, 8, 9, and 10, my lord.
8, 9, and 10 in the PIL number 35 of 2024. Copy of the writ petition along with copy of the writ petition along with the requisite documents we supplied to the newly added respondent.
My lord.
Respondents during the course of the day,
My lord.
today itself,
Yes, my lord. You
during the
can.
course of the day. When a concept of the petitioner is also directed to file amended cost item within a period of 3 days.
My
My lord, only one thing may not be correct, my lord. We are not member of any committee. We are only guardians of some words, my lord.
Indians are the guardians of some of the wards studying in the said college. We'll get to
develop.
Item 9.
Yes.
Can I please, your lordship? My lord, these are the two substitution applications. The first one listed is IA 2571 of 24, wherein the prayer is to substitute the contender number 2, who has since retired from service.
Okay.
And
This, Arpan Sakya,
yes, Lordship.
the first application is,
First application, my lord, is to substitute Sri Arpan Saikia
with,
with Sri Pranjit Kumar Wari. But
Now-
Lordship, the thing is, now the department doesn't have a secretary, so we are paid to implement the additional secretary in his place.
okay, was the matter about, was the
Well, the direction of the honorable court is to initiate the promotion process. But we file a review petition before the honorable court seeking intimating that the department wants to bifurcate the directorate and to have some amendment in the rules. Lordship has closed the review petition, closed the review petition saying that no leave is required for that and the department is free to go, free to proceed with that. Well, I have the instruction that the drafting committee has been constituted and they have already drafted, final draft is already ready for the amendment and the bifurcation. That process is there going on, they're doing it. And
then you do one thing, this, you withdraw this application number 2571 and will grant this application, next application. Because since now you are saying that, the person you sought to include, why this IA number 2571 has already retired
Lordship,
or no post of secretary is there. Now
Lordship,
you move this new application, withdraw this application.
Lordship. No, the other IA Lordship is to substitute the contentment number 1.
Contempt number 1.
Yes.
Contempt number 1, this Lakshman has,
Yes, Lordship. He has since been transferred and Sri Ajay Tiwari has been posted in his place.
okay, IA number 2571 of the 2024 is filed on behalf of the applicant with a prayer to substitute respondent number 2, Shri Arpan Sakya, ACS, with,
With Sri Pranjit Kumar Wari. He is also ACS.
with Shri Pranjit Kumar Rahi, ACS, the additional secretary to the government of Assam Mines and Mineral Department. The learned counsel appearing for the respondents has no objection if the said application is allowed. In such circumstances, the application number 2571 of 2024 is allowed. Mr. So and so is implemented as party respondent number 2 in contempt petition number 1/2000, contempt case number 1/2022 in place of 23 in place of the respondent number 2 Shri Arpan Sakya. Amended cost title be filed within a period of 1 week. Okay. IA number so and so is filed 2347 of the 2024 is filed on behalf of the contender with a prayer to impede Mr. क्या नाम है उनका?
Ajay Tiwari, Lordship.
Ajay Tiwari in place of the respondent number 1, Shri Lakshman S. IAS, the secretary to the government of Assam Mines and Mineral Department. It is submitted that since Shri Lakshman has already been transferred and in place of him, Shri Ajay Tiwari is posted as additional chief secretary, government of Assam Mines and Minerals Department. He may be included, he may be substituted as respondent number 1. IA number, the learning counsel for the respondent has no objection if the IA is allowed. The IA number 2347 is allowed. Mr. Ajay Tiwari is included as respondent number 1 in place of in place of Sri Lakshman S. IAS. Amended cost that will be filed within a period of 1 week.
Lordship. Obliged.
Filed by the contender, contempt petitioner.
Item 10.
Lordship, challenging the instant judgment, Lordship, earlier 2 writ appeals were filed, and Lordship was pleased to Lordship issue notice on those Lordship the delay condonation petitions. So Lordship, may I pray that Lordship that notice may be go and that
8 days delay.
3 days now that
My lord,
here.
just now I have got the information, my lord. My name has not been appeared. Just he informed me that this
Do you have any objection in 3 days delay?
in earlier case, I think notice was issued, my lord.
There was 16 days
Since
delay.
you are appearing, now 3 days delay, we condone the delay, what's the problem?
My lord, delay may be condoned. Yes, delay may be condoned.
I'll serve copy.
That comes up for consideration of the IA number so and so. Preferred. In writ appeal number. Preferred in connected appeal with the prayer to condone the delay of 3 days in filing the present appeal. Mr. You are appearing,
I am S.S. Goswami. I am for all the respondents.
all the respondents,
All right.
All the respect.
Mr. So and so accept notice on behalf of all the respondents. Having heard the learned counsel for the parties and after going through the contents of the application, we deem it appropriate to condone the delay of 3 days in filing the connected appeal. Hence, the IA is allowed. Registry is directed to register the connected appeal and list before this court after 3 weeks while reflecting the name of counsel for the respondent in the cause list. The learned counsel for the applicant is directed to supply the copy of the writ appeal along with the connected, along with the requisite documents to the counsel for the respondent during the course of the day,
Yes, Lordship.
during the course of.
Lordship, this matter may, Lordship, kindly tagged with the IA number, similar matters, Lordship, already noted. That may-
Remember whether,
I'll give the, right.
whether he is appearing in those IAs or not.
No, in a similar, Lordship, against this instant judgment, 2 writ appeals have already been filed. So that may be taken up along with this, Lordship, this matter.
Along with that would come separately.
Lordship. Obliged.
For admission, item 11.
Under the section 3H of the Pharmacy Act, under one is to be, out of 10,000 pharmacies in the state, one is to be nominated by the government. Your lordship will kindly see page 9. Page 9, my lord, on earlier occasions, the whole history is given. All these persons have been nominated as the member of the council, my lord, on behalf of the state of Assam. This is an important, my lord, nomination, and as your lordship got in. Page 9. These are nomination for a period of 5 years. They are to represent the state of Assam.
Yes.
And there is a bill also pending, my lord, which says, my lord, the qualification has to be, my lord, minimum, my lord, masters. That bill is also there, my lord. I will place it before your lordship. So, the bill. Page 136. And page 141 is the relevant. It is in circulation. It says the qualification has to be postgraduate minimum. Here the petitioner, he is a master's, PhD, and also a senior lecturer in the Institute of Pharmacy in Assam Medical College. And the private respondent, he is a pharmacist in Assam Vidhan Sabha for 2 years diploma course. I'm just pointing out the facts. Page 75 now. This is the government notification. It authorizes the Medical Education and Research Department, column 2, my lord. Your lordship will kindly see Roman 2, pharmacy is there. So in the interest of public service, serving the
75.
government, my lord, page 75. So pharmacy is assigned to Medical Education and Research Department, column 2, your lordship will get it at
All
Roman
India
2,
medical colleges and hospitals, dental
Yes,
colleges,
yes.
nursing colleges, pharmacy.
pharmacy.
So
So accordingly, my lord, your lordship will kindly see page 68.
68.
6-8. This was the 3 names, my lord, considered by the department, including the name of the petitioner. These are all on the basis of the higher education qualification.
Right.
Page 68.
Yes.
Then 69, this is the selection took place by a group of persons, my lord, for selection committee, and the petitioner was selected. Now, page 72, it forwards the name of the petitioner, my lord, to the Registrar cum Secretary, Pharmacy Council of India. Has your lordship. Petitioner name has been forwarded to the Pharmacy Council of India. In these circumstances, page 73, I'm directed to, this is by the Health Department. I'm directed to inform you that the following registered pharmacist is hereby nominated to. So this is Mr. Sudhir Chandra Saha, respondent number 6, and his name has been forwarded. And ultimately, my lord, this impugn order was passed, which the learned single judge states, my lord, we have not challenged it at page 73. $74, my lord. This is the impugn order. Now, your lordship, and kindly
Yes,
kindly see, my lord, pay that executive instructions, page 89.
89.
Rule 25. So there is, my lord, mismatch in regard to, my lord, two departments.
Yes,
My lord, my lord, executive instruction, page 25, my lord.
yeah.
Page 89. Because your lordship has seen, my lord, two departments has got two different views. The MERD department and the health department. If a question arises regarding ascertaining of a case in between departments and there is no clear specification to which a case properly belongs, the matter shall be referred for the decision of the chief secretary, who shall, if necessary, obtain the orders of the chief minister. Now, rule 28, your lordship, let me see. Notwithstanding anything contained herein above, the following cases shall be submitted to the chief secretary in the manner as specified herein below. The chief secretary shall be kept apprised of all the important decisions of various departments. This is an important decision as regards the nomination of a person. The chief secretary is the head of the administrative machinery in the state and is responsible to ensure efficiency of functioning of the entire state administration. His mediation shall be sought as far as practicable in all cases where there is a difference of opinion between the secretaries. Now, number 2, my lord, the chief secretary may, on the orders of the chief minister or of any members, or on being apprised by a secretary of a department or on his own motion, call for papers or files relating to any case in any department, and any such request by him shall be complied with. The chief secretary may, after examination of the case, submit it for the orders of the minister in charge or of the chief minister through the minister in charge. So my page 100, 41. If any question arises, page 100.
Yes, sir.
If any question arises as to the interpretation of these rules or as to the department to which the case properly belongs, the matter shall be referred to the chief secretary for a decision which shall be final and binding. So my only prayer before the court was, my lord, this is an important nomination. On all other occasions, my lord, they have sent persons who have got minimum master's degree and PhD degree, and petitioner being a master degree and PhD degree holder.
Where is that bifurcation of two departments?
75.
There is 75.
75.
So two departments are there, health and family welfare department, medical education and research
Education.
department.
My lord.
This rule 25 or the executive instructions which you have referred to,
My lord.
it says that if a question arises regarding ascertaining of a case between the department and there is no clear specification. So where was the question?
My lord, here clarification is there. Already, my lord,
What was the question?
it is clear, my lord, that
The medical education and research department, they have nominated or sent your name
yes,
And thereafter, this Health and Family Welfare Department has changed that.
Change that.
With the concurrence of the
Minister.
medical education and research
Minister.
department, where is the
Well,
question
what-
arises?
What I submit, my lord.
And the approval of the minister concerned.
No,
Where is the
that,
question?
what I submit, my lord, in view of the executive instructions, because if there is an important matters, it is an important matter.
But
I do not-
ultimately, a question should be there, at
The-
least this medical education and this research department should raise the flag
Yes,
that this,
Now, what-
we have
what are-
nominated him, why you have changed this? They concurred with the opinion of the Health and Family Welfare Department. The
given a
minister has
detailed-
given the approval. Where is the question
my
arises?
lord, detailed letter
was
they
the
have
question?
given. My lord, what I submit, my lord. Come what may, this, taking into consideration the earlier action of the part of the government in sending the nominations, your lordship has seen the qualification of those persons who have.
Where there
for
is a
20 years.
difference of opinion
Yeah.
between two departments, certainly
When-
the matter has to be referred to the chief secretary. And if required, so approval of the chief minister is required.
Here the
But here, the other department is in tandem with the other department.
minister
What is the
has
problem?
agreed. Only difference is, my lord, the minister has agreed to the withdrawal of the name of the petitioner
Then,
and they putting the name of the.
and he is the in
respondent.
charge of this
What I do
medical
not know.
education and research
I do
department.
not know, my lord, whether this earlier facts regarding high qualified persons were. My lord, what I
The thing is
submit.
that learned single judge has rightly
what-
said, when this department has no objection.
Learned single judge has said, my lord, that you have not challenged that impugn order dated 29/8/23. That your lordship will get it at 3. But what I submit, my lord, subject to what your lordship may say, because I do not know whether they, my lord, the authorities have been brought to the notice.
Para number 19 of the impugned judgment.
Yes, page 301.
Yeah, read.
Yes. The purely administrative decision, the power
This
of.
court has also taken note of the impugned communication data whereby the respondent name name was nominated and nomination made was withdrawn. Not only the concurrence of the Health and Family Welfare Department of the Government of, but also the Minister of both the departments, Health and Family Welfare, as well as the Medical Education and Research Department. Under such circumstances, the opinion, the question of interfering with the impugned nomination so made in favor of the respondent by the Health and Family Welfare Department, why the impugned communication does not arise.
Well,
That is what we are
department's
saying.
affidavit, if your lordship looks into, it says there is my lord, page 196. Page 196. Department's affidavit, 196, page, your lordship will kindly see page 201.
196, what
It starts from 196,
Yes.
201, last sentence, second paragraph, my lord, second sentence. Although the matters relating to pharmacy institute, has the lordship got it?
last para,
Last para,
although the matter.
and last sentence. Although the matters relating to pharmacy institutes were under the domain of MERD, however, the notification has not explicitly detailed as to which department shall deal with the matters pertaining to Pharmacy Act, PCI and APC. Matters like election of pharmacy council, some pharmacy payments of fees of so and so, cases on fake registrations of pharmacy, etc., are being dealt by a Health and Family Welfare Department. So their own department's affidavit says, my lord, there is a.
Hence, it can be concluded the activities of both are based on internal arrangements, depend upon the nature and matters of
Yes.
process.
So what I subject to what your lordship may say. My lord, let the authority once again look into that earlier occasions, we have nominated these persons.
You are appearing for
I'm appearing for the, both the department, my lord.
the department, so is appearing for the this private respondent?
No, my lord, nobody had it appearing today, my lord.
It has come for the first time.
First time, my lord.
Having heard the learned concept for the appellant, we deem it appropriate that matter requires consideration, hence admit issue notice, Mr. So and so, accept notice on behalf of the respondent number
1, 2, 3, 4, and 5, my lord.
1, 2, 3, 4, and 5. Let notices be issued to the respondent number 6 only. Returnable 4 weeks. However, in the facts and circumstances of the case, particularly taking consideration of the fact that the health and family welfare department, medical education and research department has no objection to the nomination of the respondent number 6 as member of the Pharmacy Council of India. And the said decision taken by the Health and Family Welfare Department has been approved by ministers of both the departments. We don't find any case for grant of interim stay. Hence, the application for interim stay, rare have kind.
I have given a separate petition, my lord. What I submit.
Therefore, the IA number so and so.
Let notice go at this.
36 of the 2000.
Instead of rejecting it, my lord, let notice go at this stage.
We have already. The IA number so and so is dismissed. IA number so and so seeking interim. There is dismissed.
Obligation.
To register the respondent 6.
Item 12.
May I please the lordship? Writ appeal against the judgment and order dated 5/8/2024, lordship.
5/8/2024.
Yes, lordship.
5/8/2024 is order
Order lordship annexed to page 47, lordship.
47. By the learned single judge.
Yes, lordship.
Yes.
Lordship, appellant is being aggrieved under section Assam Municipal Act under section 46(4), lordship. Lordship, the said section is said that any meeting shall be stand adjourned to some future day to be appointed by the president, and 3 days notice of such adjourn meeting shall be given, lordship.
By whom?
Lordship, respondent authority, lordship.
Respondent
Those who have been,
who is the respondent authority?
lordship, those who have brought against the no confidence motion.
Those persons are required to give you a notice.
Yes,
Or the
lordship.
authority concerned.
Or yes, lordship, authority concerned.
Which authority concerned? Which officer?
These are as your civil lordship, those who have been,
SDO civil.
yes,
He
lordship.
was required to issue notice of 3 days notice.
Yes, lord.
And he has issued notice how many days?
Prior 3 days, lordship. Prior 3 days, lordship.
Prior 3 days means
Lordship, meeting shall be given prior to 3 days, lordship. any special meeting have been called by the authority, the prior to notice served upon the.
3 days prior notice is required to be served.
Yes,
And
Lordship.
This matter, how many days notice was given?
Lordship 24/7/2024, but meeting was held on 25/7/2024.
1 day notice was given.
Yes, Lordship.
So whether that provision regarding issuance of notice of 3 days by one authority concerned is mandatory or directory?
Lordship mandatory, Lordship.
No, it can't be. It is directory provision.
Lordship.
Yes. It is directory. If any action
Lordship.
is to be taken by authority concerned
Lordship.
in a case of no confidence motion,
Lord.
and if that authority fails to take that action within stipulated time, it is mandatory, not mandatory.
Lordship.
Direct provision.
Lordship, as for provision is stated, Lordship, Assam Municipal Act, Lordship. If there is a violation, there is a already Municipal Act is also
How many persons have expressed no confidence against you?
8%.
Out of,
10, Lordship.
then how can you be remain on the seat? It's a democratic institution.
Lordship.
If you lost the confidence, why we go into all these technicalities?
Lordship, a
We are not supposed
provision.
to go into all these technicalities.
Lordship.
Whatever it may be, you lost your confidence of the majority, then you can't remain in the office.
Lordship.
Ultimately, it's a democratic office.
Lordship.
And the ward members are representing the will of the people. If
Lordship.
the people don't want to, why do you want to stick on this? Why do you want to stick on this
Lordship.
post? Once you have lost the confidence, leave it. Again, contest the election and come.
Lordship, as per provision of Lordship, it
Whatever
is
the
stated.
reason may be, why
Lordship.
should we go into all these technicalities? A person who lost the confidence, why should we interfere?
Lordship.
That's all. Matter ends here. Win the confidence of the people and again come to the office. That's
Lordship.
all.
Our grievance is only for notice, Lordship.
Yes. Yes.
Lordship. It is our grievance, Lordship.
Okay, Nikhil. The appellant has approached the learned single judge being agreed with the no confidence motion passed against him on 25/7/2024.
It's a lady.
Her
Motion was against a lady, is it?
lady passed against
Lady,
her.
Lordship.
Lady, this
Yes, Lord.
passed against her. Nikhil, hai? 24 and which resulted into removal of the appellant from the post of chairperson of Ita Board Municipal Board. Full stop. Learned, the appellant has raised a grievance before the learned single judge that as required under section 46(4) of the Assam Municipal Act 1956, 3 days prior notice has not been served upon her. Learned counsel for the learned single judge has concluded that the section 46(4) of the Act of 1956 is not applicable in the present case, and the relevant provision is section 43(3) of the Act of 1956, which stipulates that if a chairman or vice chairman fails to call a meeting to meet within 20 days after such a requisition has been made, the meeting may be called by the persons who signed the requisition. Full stop. Having heard the learned counsel for the petitioner and after appellant and after going through the material available on record, we don't find any case for interference, hence the writ appeal is dismissed.
Highly applicable.
Item 13.
Is it connected with the supplementary list?
My lord, it is, two petitions, two appeal has been preferred, my lord. My lord, the honorable learned single judge has held that the matter is premature. But the lord, we have,
What's wrong with you?
my lord,
What's wrong with the?
order, my lord. My lord, the appeal which we have preferred, my lord, is
Your
personal,
grievance is Jirat compensation.
Zirat as well as the conversion of the land from wheat to industrial. Now that application of mine is pending before the authority. They can either allow or reject, my lord. Only that much relief we are asking, I am praying for, my lord. My lord.
Sorry, sir, this is once you have raised your objection, that will be there.
No, my lord, the objection has not been disposed of, my lord, and on the other hand,
Disposed of within due course of time.
no, it has,
We should interfere in this at this stage.
no, my lord, the appeal which I have preferred, my lord, may kindly see the notice, my lord. My lord is at page 39, my lord.
Yes.
In the page 39, my lord, the schedule, the 10 days time had been given, my lord. In the second paragraph, the schedule of the above land acquired is published in the newspaper public today. Thereby, in accordance with subsection 3 and 4 of and section 3J of the said act, before proceeding to determine the amount under section so and so and so and so, public notices are hereby issued to all persons interested in the land specified in the schedule below within 10 days from the date on which publication of the notice they may submit their claims, either in person or by agent or by legal prescriptioners. Now, my lord, basing on this notice, I made an my lord appeal objecting that my land has been earmarked. My lord may kindly appreciate, my lord is at page 40, serial number, my lord, 11.
Yes,
Serial number 11, my land has been shown as non-agricultural heath.
okay.
Now that, my lord, that objection I have raised by preferring this appeal is at page 41, my lord.
Yes.
that my land should be converted into an from a non-agricultural bid to commercial oblique industrial land. Now that application, my lord, this appeal was still pending before the authority. They did not take any action, my lord.
Unless they decide, say.
Exactly, my lord.
Yes.
Now they are not deciding
It's
and
not only your objection, there may be some other objections.
Other objections are also there.
All those objections should be decided in due course of time.
they are sitting silent over the my appeal, my lord. Now, my lord, may
Notice is
kindly,
dated, notice is dated.
notice dated, my lord, this is. Date to the end.
How you are agree?
My lord,
If
I
they
have,
have not decided your objection, still they have not acquired your land.
no, they have acquired, my lord. They already, it has been acquired and the process of,
Okay,
my
then-
lord,
Then whatever the decision of the authority
My
concerned,
lord.
you have a remedy to challenge it under section 3G.
no, but my lord, they are required to decide the, my appeal, my lord.
Maybe, sir.
They are required to decide, my lord.
You can just.
My lord, only. But my lord, my only limited prayer, my lord, was that this appeal may be disposed of within a short period of time, my lord. That relief I am asking for, my lord.
Item 20 also same.
Same, similar, my lord.
Same, because
My
these writ petitions are filed. The writ appeals are filed.
Appeal.
Appeal are being executed.
We can interpret. They do two repetition lots, writ
Go
appeal.
ahead, go ahead.
First writ appeal, which is 296, this already been 3G, TD is over.
Correct, correct.
3G has come up. Regarding second, I can little bit because documents is not saying here, but first case already 3G is over. 3D is over, 3G is
The
this one.
compensation has been ascertained. That has been determined.
That because that is that only instruction if at all required because 3G already a publication, so within 10 days we'll publish this determination that notification first case it has been shown.
You have
And
already-
therefore,
Just, you
My
have
lord.
dealt with these objections or whatever it may be.
no, that part, because after 3D, then your lordship, after declaration of 3D, for second case, somewhat it is there because 3C is there, not been determined the second case. First case, lordship, anyhow, lordship pass order, I'll do it because representation.
This writ appeal is filed by the appellant being agreed with the order dictating Article 7/2024 passed by the learned single judge in writ petition number 3748/2024 whereby the learned single judge has refused to interfere in the writ petition filed by the appellant while observing that the writ petition is premature. Full stop. The petitioner, the appellant has approached the writ court seeking a direction upon the respondent authorities to dispose of the appeal / representation / objection filed by him on 13/3/2024 in response to the notification issued under section 3C of the National Highway Act 1956. Full stop. The learned single judge has observed that since the determination of the compensation is not done by the authorities, by the competent authorities, the writ petition filed by the appellant is premature. Full stop. Having heard the learned counsel for the petitioner after going through the material available on record, we don't find any case for interference. Hence, the writ appeal is dismissed. However, it is expected that if the authority concerned has not decided the objection filed by the appellant till this date, it is expected that the same shall be considered and decided expeditiously.
Obliged.
May I pray for a fixed time, my lord?
Expeditiously.
First time
And the date of representation are same in item
but-
20 also?
My lord, it is slightly different, my lord.
Date of order and date of representation is.
Yeah,
same.
Date
order
of
is
order,
same.
judgment is, order is same.
Order
but
dated is same, my
representation
lord. The
same.
representation dated, my lord, is 12/1, my lord.
Okay, sir.
13/3/24, my lord.
Where else?
Date of 13/3/24.
My lord, obliged.
Obliged.
Item 14.
My lord, in this petition, my lord, we have challenged the rule 14 of the, my lord, 2018 rules, my lord. My lord, before proceeding, my lord, I have committed a small typographical error in my petition, which I have detected of late, my lord. A small blank has been left out, a date is required to be inserted, my lord.
Which para?
My lord, in at page 19, my lord. 19, ground C, my
From
lord.
the perusal order date.
Yes, my lord, that part, my lord, it is my inadvertent mistake, my lord.
What's the date?
My lord, it is, I'll put it, my lord.
Okay, fine.
My lord.
Now,
My lord, the ground which we have challenged in this petition regarding rule 14, my lord, of the Assam Secondary Education Rules of 2018.
have you quoted that rule in this?
My lord. My lord, yes, my lord. My lord, may be pleased to find page 16.
16. This is rule 3, you have quoted.
My lord, rule 3 is also connected, my lord.
There is rule 14.
Yes, my lord. No, my lord, rule 14 I have not quoted, my lord. My lord can have a, find it from the book, my lord. Is that page 35 of this manual, my lord.
35.
Page 35, my lord.
Yes.
Recruitment to the post of headmaster, superintendent and procedure thereof, my lord. The post of headmaster of a high school and superintendent of a high madrasa shall be filled up by promotion from the candidate amongst the graduate teacher and as per the district by seniority list on the recommendation of the district selection committee constituted under rule 16(2). My lord, we are not aggrieved with this, but what has happened, my lord, the assistant headmasters is being already a post higher than the graduate teachers, my lord. There are two, for the purpose of not feeding the post of headmasters. Now, two posts can be used as a feeder cadre, my lord, that is graduate teacher and assistant headmasters, my lord. Now, but what they are doing now, after my promotion as an assistant headmaster, as per the provision of the rule, both the cadre has been clubbed together, my lord, the assistant headmaster and the graduate. Now, as a result, my lord, in the seniority, I am way back, my lord, and in my entire career, my lord, I will never be able to promote.
Provision you are aggrieved of this?
My lord, 14, rule 2. My lord, rule 2, my lord.
Yes.
Provided that the graduate teacher shall include the cadre of assistant headmaster, my lord. This part, my lord.
This rule 2 or?
My lord, rule 14, sub rule 2, clause B, my lord. Proviso.
He
Pro-
must be. He must be at least 10 years of.
That-
teaching
yes,
in
my lord.
the
That I am
graduate
not
age.
agree,
Further,
my lord.
graduation include in the cadre of assistant headmaster for the purpose of selection in the post of headmaster. Seniority of the assistant shall be counted from the date of joining as graduate in the
My lord.
graduate scale of pay.
My lord.
You are the assistant teacher.
I am the assistant headmaster at present, my lord. The assistant headmasters are being promoted from the post of, my lord, graduate teachers, my lord. Now, as I have already been promoted and higher in the cadre, my lord can verify from the cadre rule 3, my lord.
But if you are, you have earlier joined.
I have already joined as an assistant headmaster by a regular
How the
promotion,
seniority is going to be affected because it says.
my lord.
Provided they shall also include in the headmaster for the purpose of selection and seniority of the assistant headmaster shall be counted from the date of joining as graduate teacher with graduate scale of pay.
My lord.
Notice, yes, Mr.
My lord,
Perhaps this rule was upheld by this honorable court, my lord, in two judgments. I remember I was trying to search. my lord.
This very.
Yes. This assistant headmaster and graduate teachers, how they are to be taken up in the same regulations. I'm just trying to trace out, my lord. I remember.
Place it on record.
I'll do that. I'll do that.
That is already there.
I think.
For the password for the time being. If you are able to get the.
For the timing, my lord, I'll just try to find out if it is there. I remember two challenges are there.
Day after tomorrow, we will.
I'll just try to find. 14 as it is upheld. Yes.
Let him find.
I'll just.
Lord, can it be taken up?
That has already been upheld, then there is no point in,
My lord,
and if it is not upheld, then we'll ask them to file replies.
Lord, can it be taken up? Day after tomorrow. আপনারা কবি না
Senior pastor.
Yes.
Item 15.
My lord, by this. Sorry. My lord, this PIL highlights, my lord, how the people are being forced to pay penalty for alleged violation of the Motor Vehicles Act without there being any order, adjudication or order by the court. And when we file the, my lord, a representation, the authority says it's not required. There is nowhere it is provided that in a case which is compoundable in nature, notice should be given. And there is a forced compounding. I'll tell you, my lord, how they are doing it. My lord, they take the photograph or CCTV footage of a vehicle and they enclose with the e-challan, upload it on a Vahan portal. There is a portal called Vahan portal. They upload it there and they send it to the registered owner. Once it goes to the registered owner is forced to pay. Forced by stopping all the transfer of the vehicle. The registration will be stopped. The renewal of the driving license is stopped. Renewal of the pollution under control certificate is also stopped. So there is no way but to force. They force us to pay. If your lordship will see their
If there is a violation, and apparently there is a violation, then why, how this person can be escaped from liability of challan or?
now,
penalty?
my lord, that suppose they allege that there is violation and they charge us, the violator, under a particular section. Now, the violator will have right to defend himself by saying that, look, this section doesn't apply. I'm asking that question to myself.
Yes.
My
Where is
lord,
that provision?
your
Which
lordship will
provision
kindly,
can I read out?
first I will take your lordships to SOP, that is a standard operating procedure dated 17/12/2018. At page 64 it starts. The relevant is at page 68 of the paper book. 4.3, generating challans for violation.
64.
64 it starts, SOP starts. Relevant, which I am referring to, your lordship will get at page 68.
68.
68.
Yes.
If a challan is pending or has not been disposed, then all transactions involving vehicle, that is NOC, fitness, tax, etc.,
And for driving license,
Which provision you are referring?
I am referring to 6. Clause 6.
Clause 6.
Clause
Yes,
6.
If a challan is pending,
If a challan is pending or has not been disposed, then all transactions involving vehicle, that is NOC, fitness, tax, etc., for driving license, that is renewal of the address change, etc., are not permitted and are reflected to the traffic enforcement agency across the India. The violators are required to compound the closed pending cases as early as possible to start availing these services. Now, my lord, this is a forced compounding.
just a minute, sir. Suppose if challan, a person receives a challan, e-challan,
Yes, yes,
then either he has to deposit that amount or whatever it may be,
yes.
or is there any provision that he can contest it before the concerned court?
Well, the
Is
what
there-
your
Is
lordship,
there any provision that he can contest that challan?
yes,
Where
yes,
is that, sir?
208 of the Motor Vehicles Act.
So then how the person, if you are not accepting it, because it says if the challan is pending or has not been disposed.
My lord, how it will be disposed unless it is sent to the court? What they mean is that it is not disposed means you come and pay. Once you pay, it will be disposed of.
Every challan is supposed to go to the court, sir.
If they are saying no, that's what I will take your lordships through the affidavit, the reply that they have given.
Mr. Mishra,
Well,
I will request you to please check out on this because this e-traffic channel module has been set up by the High Court in collaboration with the Transport Department of Government of Assam.
yes.
And this is under a program of the Government of India. Now, there are a few things I can say from my personal knowledge because I was very much behind this IT.
My lord.
You see, the module operates in this premise that if there is a violation of traffic norms, instead of sending each and every case to the magistrate and cases piling up,
Yes.
magistrates being occupied with these matters for months and years together, this method was developed so that proof of violation is sent to the owner. If he accepts it, then through
He will pay.
electronic transfer,
There is
he
no
will pay.
difficulty there.
The matter ends there.
Yes, if he doesn't
If he
accept,
doesn't accept, then he has an option to come to the court and challenge it.
that, my lord, there is a force compounding. They say you pay, otherwise your license will not be renewed. Now, the person goes to the e-court, which was constituted by your lordships.
In fact, sir, my personal knowledge is that
Yes,
in Rajasthan, they have generated e-challans of many of the vehicle owners, and they were not served upon them. They were not served upon them, and suppose if after second or third violation, any person is stopped, or even while the vehicle is moving, the traffic people stop them and said, there are 2 challans pending against you. Of the year 2021 and 2022, there are 2 challans, either you pay or you don't, then we are going to whatever seize the vehicle and all. Then these matters comes before the High Court, and in fact, all those matters in the Lok Adalat, the High Court took up these matters, and all those challans were disposed of by way of compromise and nothing, and without paying anything. Because since in 2021, there was a violation and they have served the notices in the year 2023. Therefore, all the mobile courts have disposed of all those matters, and certainly it was brought, all those challans were pending with the court.
but here, my lord, they don't send the challan, and deliberately they don't send the challan to the court. And it's an accepted position if your lordship takes up the additional affidavit.
This gives us an opportunity to see how things are. That's the only reason, just to see whether things are operating as per the directions. Otherwise, there is nothing. Otherwise, there is nothing. This we'll get an opportunity to ask them, clarify how things are operating. Whether it is happening. That's for the monitoring.
What is this affidavit you have filed?
My lord,
Affidavit?
there is an additional affidavit
Yeah.
filed by us, my lord.
Well,
Their reply is there.
they have already filed reply.
No, no, there is a representation. It's a letter against our representation. That
You are
will
appearing
show.
for the transport department.
Lordship, I'm appealing for the transport department.
Clarify this position.
My lord,
Why a person, if he is willing to contest,
my lord.
then why he is forcing that, why you are forcing him to pay the challan? So why this force compounding?
Lordship. Lordship, may I submit, my lord, one thing?
Yes.
Lordship, may kindly have a look the Central Motor Vehicle Rules, my lord. 167(7). Rule 167(7), my lord.
Yes.
May I read, my lord?
One 167.
7.
That is
167,
understanding.
Rule 7.
Says what?
Lordship, may I read?
Read.
If a challan is due beyond the time period specified in sub-rule 5, except in case of offenses instituted for prosecution by a court, then applications with respect to the license of the offender or registration of motor vehicle, as the case may be mentioned in the challan, shall not be processed by the licensing authority or registering authority, as the case may be, except application relating to permit, fitness, taxes of motor vehicle. And Lordship, the MOT has issued time to time some guidelines to us, my lord. And these guidelines, this notification is not under challenge here.
Notification, give me a copy.
You mean to say that what is the provision in the SOP is in consonance with this?
My lord, and the subsequent SOP, my lord, the recent SOP.
So, Ms. Bora, why don't you file an affidavit?
Lordship,
in
I'll
on
file,
this
my lord.
case?
File an affidavit.
My
I'll
lord,
file.
just two things, if your lordship permit me. The difficulty that a person who wants to contest will face. My lord will kindly see the provision contained under 179. That is the provision, my lord, which they always for 179 for unauthorized parking. That's very common. This is of the Act, Motor Vehicles Act, 1988, Motor Vehicles Act, if your lordship kindly says.
Rule
There are two things,
179?
my lord.
Rule 179.
Section 179 of the Motor Vehicles Act, 1988. Your lordship got me, lord.
Yes.
My lord, I'll place 179. Whoever willfully disobeys or any direction lawfully given by any person or authority empowered under this act to give such directions or obstructs any person or authority in discharge of any function which such person or authority is required or empowered under this act to discharge, shall, if no other penalty is provided for the offence, be punishable with a fine which may extend to 2,000. Now, this fine is on a scale. The quantum is on the scale. Now, it is in challan mentioned 2,000. Then the person who said to have violated is forced to pay 2,000 because there is no adjudication. There is no adjudication. Just another point I will just place, my lord.
We
If you're-
understand that problem, sir.
My lord,
Without there being adjudication, if a person wants to contest
yes,
a particular, whatever the fact they have mentioned in the e-challan,
yes,
then certainly you should have an opportunity to do that.
that's my case. Now, if it's a lordship, how an accuser has been made adjudicator by the rules, I want to place it for your lordship. My lord will kindly have rule 16A 7 at page 63, my lord.
Let them find their
My lord.
response. That's why.
My lord.
we are-
But then, my lord, but the problem is that they should not realize from those who do not want to compromise.
We'll fixing a date of 2 weeks only. And if that, this problem, whatever you are raised is persisting since, wait for 2 weeks or more weeks.
My lord, here, as your lordship has just given the example of Rajasthan,
Yeah.
here, my lord, one of our colleague, he went to renew his pollution under control certificate.
Then they said, yeah, there is a.
There
challan
is a,
pending.
and your lordship knows under 468 of CRPC, there is a corresponding similar provision in BNSS. After 6 months, the court cannot take cognizance. They keep the challan with them and they forced the person to pay, and he was forced to pay. Your lordship wants, I can show at page 72.
We understand, sir. Let the clarification be come from the state government.
Only thing is, my lord, in the meantime, every day, people are being forced to
But
pay.
if-
I just said, my
If
lord,
it is
because,
going on from so many days, let's wait for 2 weeks.
my lord, my lord.
Lordship.
Issue notice. Miss, so accept notice on behalf of the,
Lordship, I am for 2, 3 and 4 for transport department.
and who is appearing for the other department? Or.
17,
Who is appearing for, 2?
Lordship, I am appearing.
2,
2,
3
3 and 4.
Yeah, issue notice. Accept notice on behalf of the respondent number 1. So is, accept notice on behalf of the respondent number 1, 2, and 3. Mr. So is appearing on behalf of the respondent number 5. Copy of the writ petition is supplied to the respective councils during the course of the day. A council for the respondents may file their response to the PIL petition. To this PIL petition within a period of 2 weeks, just after 2 weeks.
Lordship, I am so deeply obliged.
Within a period of 2 weeks while supplying copy of the counter affidavit in advance to the council for the petition.
Lordship.
Can it be on 17 or 18, my lord? No, I leave it to your lordship.
Any date, whatever.
18.
Lordship.
Obliged.
23rd পাছত হ'ব নেকি? 23rd পাছত হ'ব
ঠিক
নেকি?
আছে।
My lord, can be after 23rd.
Whatever date.
24th করে দিয়ে।
Whatever date.
24?
I'm deeply obliged.
Passover Metro 14.
Yes.
My lord, this is against me, my lord.
I will appeal.
My lord.
The same rule, my lord, the same grounds.
Now what else?
And my lord, in the similar line, my lord can dispose of, my lord. At least
Paragraph 4 is his grievance.
Despite this writ petition, the petitioner has the validity of the rule 14.
To be.
Rule
in 2B, my lord.
Rule 14 2B, 14 in bracket 2 and again bracket small b of the Assam Secondary Education Provincialization Service Rules 2018.
18, my lord.
2018. Full stop. Please notice that the validity of the above referred rule has already been upheld by the division bench of this court in Bhaben Bhatta versus State of Assam and so reported in so and so. Yes, for Reported in view of the fact that the validity of the above referred provision, which is under challenge in this petition, has already been affirmed by the division bench of this court. We don't find any case for interference, hence this writ petition is dismissed in terms of so and so, so and so.
any jana silent hai, to naam to ever silent.
Item 16.
My lord, in this case, my lord, applicant before your lordship was working in the department, my lord, as a my lord grade 4 capacity, and he rendered service, my lord, more than 36 years. And he was superannuated on completion of 60 years of age. But departmental authority, my lord, declined him, my lord, the pensionary benefit. Hence, he approached before this, the honorable single judge. And honorable single judge, my lord, rejected his writ petition on the ground that, my lord, he failed to, my lord, satisfy three conditions for pension. And these three conditions, my lord, are also quoted in the impugned judgment itself, my lord, page 21.
Just
And within last couple of, my lord,
you are a work charge employee.
my lord, it is just written against my name, my lord, without any basis work charge. But otherwise, my lord, my nature of appointment and continue.
Whatever it may be, until there is employment must be substantive and permanent. That is that.
Now, my lord, here, my lord, in the meantime, my lord, within last couple of days, my lord, another two, my lord, judgment was passed by this the honorable single judge in favor of those people, my lord.
In favor of those people, grant them pensionary benefits.
Well, yes, my lord, directly, my lord, mandamus issued, my lordship, kindly have a look, this last judgment.
Which judgment? Where is it?
Yes, my lord, same, my lord, department, same, my lord,
Where is that judgment? Which judgment you are referring?
my lord, I am, my lord, referring page 87, my lord,
87.
87, my lord. Page 87, my lord, relevant portion, page 97, my lord. It is a, my lord, elaborate judgment considering, my lord, everything, my lord. Paragraph 22, my lord.
না, 24 দিন লাগে, এই তো job, এটা regulation বিষয়, 5% benefit বিষয়। Minus page 97 of the same judgment, minus. The London single has held at para 24, that it should not be treated as a precedent.
Even though it should not be treated as a precedent, how it can be?
And that about that entire foundation of the case was the widow came before the court seeking regulation of service.
Her husband was not found left out 11 times due to mistake. How can this, how you will get the benefit from this order, sir?
My lord, another judgment, my lord, lordship, can you have a look, page 61, my lord.
61.
61, my lord. And relevant portion, my lord, page 86.
86.
86, my lord.
Oh,
It was provided that, my lord,
Just.
Defendant is binding.
they are going, my lord, selectively.
You are not placing the relevant orders before the court. Huh?
My lord, in fact, the judgment which is relying, my lord, that same judgment, page 85, my lord. Paragraph says, my lord, that Upendas is binding, and that.
Of course it is binding, even if it says or it doesn't say.
My lord.
So then how,
এখানে judgment দেখাবো কোনটা?
Supreme Court judgment, my lord, page 45.
file your counter,
My lord,
file your counter,
we have, we'll file, my lord.
file your counter, why this? So orders are being passed. Okay, Mr. Gogoi is appearing on behalf of
The Department of PHE, my lord.
Department of PhD.
PhD, my lord.
PhD. He placed some time to file counter to the date appeal. List after 3 weeks while showing name of Mr. D. Gogoi as counsel for the PhD department.
Diploma.
Item 17.
Yes. Item number 17.
Yes, ma'am. My pleasure.
Just a,
My lord, here in this case,
just a minute, sir, please. Where is that order of 2017?
223. 23.
Mr. Bora, why the court order was not complied with, the 2017 order?
I will have to obtain it, my lord, because that time, my lord, whether it was properly served or not, or what action was taken, my lord. Because the health department was not alone to take action in terms of the order, my lord. The payment has to be come from the central, because it was a central government scheme, my lord.
It may be, if there is something due, supposed to pay, and if 2017 order you are not challenged, make the payment.
Yes, my lord.
These poor persons, why these poor persons should? How many petitioners are there?
Now, my lord, in writ petition, there are altogether 200 plus. Now only 15 before your lord.
Other people?
They are unable to approach, my lord.
Only 15 persons have approached.
Now, in appeal, only 15 people.
And writ petition originally,
256.
and you are seeking arrears from which date?
Your lordship, only by page 326. From the date of appointment, my lord, appointment was made in between 86 to 90. And the honorable court order was up to 39/2010. From the date of appointment up to 39/2010. Page 326.
Appointment is from 84,
From 86.
86. This order has not been challenged.
Not been challenged.
Notice, Mr. So accept notice on behalf of, you just
Yes, my lord.
indicate the names. You are appearing which respondents?
Appearing for the finance department, respondent number 4.
All the respondents are being represented?
Yes, lordship. Yes.
Okay, you mentioned it. Mr. Montes, note their representation. Mr. So-and-so, issue notice, Mr. So-and-so puts the appearance on behalf of the respondents. Service is therefore complete. The counsel for the respondents may file their response to the writ appeal within a period of 6 weeks. Copy of the writ appeals be supplied, a copy of the writ appeals be supplied to the counsel for the respective so-and-so within a period of 1 week.
I am obliged.
Supplementary list, item 19.
Made please, your lordship. My lord, in this case, NIT was issued by the excise authority, my lord, for settlement of liquor shops in the Lakhimpur district. Now, first an NIT was issued on 6th of January 24. That due to, my lord, adequate number of bidders, my lord, that NIT was done away with. And the second NIT was issued on 23rd of February 24. Now, both, my lord, both the NITs have been considered. If your lordship should first come to page number 88, my lord.
Both the NITs,
What had happened, my lord? Certain conditions from the first NIT and second condition, certain conditions from the second NIT, both will be considered.
first NIT, no response was there.
Response, yeah,
No,
no response.
The new NIT was issued.
New NIT was issued. If as far as the first NIT is concerned, my lord, if your lordships will kindly come to page number 88.
88,
Yes.
yes.
No, first NIT to 88, my lord.
Just for.
Yes. Milord will kindly come to page 88, Milord.
Yes,
This is the checklist of the bidder eligibility criteria.
in the first,
First,
yeah,
please come to the third column, my lord.
yes.
Specific requirement.
Checklist of the bidder eligibility criteria in technical,
Yes,
specific requirement.
yes. Now, my lord will kindly come to page 90.
90.
Yes.
Yeah,
Serial number 12, site information.
site plan certified by an engineer, bidders right.
12, my lord.
Of the.
Site information, site plan certified by an engineer and the bidders actually. We are concerned with the site plan, my lord. So a site plan signed by an engineer is required to be annexed along with the bid.
Fine.
And please come to me, Lord, page 88 for a moment once again. This is annexure C.
Yes,
Now, my Lord will kindly come to the new tender at page 96.
88 is, page 88.
Yes, page 88 was the part of the first NIT.
Fine.
Yes, now I'll have a lot of
And
kind
that,
attention to the,
This, condition number 12 was site plan is to be certified by an engineer.
yes, yes. Now, my Lord will kindly come to the new NIT at page 96.
96.
My Lord will kindly come to page 97.
96.
Please come to page 97, my Lord.
Yes,
Documents to be submitted along with technical bid.
yes.
Now, please see serial number 18, my Lord.
18.
18, yes.
Annexure.
Annexure CDE. So C is that checklist, my Lord, that engineer's requirement. Now kindly come to 22. Same page. In addition to that, my Lord, site plan duly signed by assistant executive engineer.
This second advertisement is in continuation of. the
Something
other.
like that.
Where is that mentioned?
Yes, that is there, my Lord, at page 96. Yes.
Yes.
For details, after the first box, my Lord, for details, please refer to previous bid document and following revised timeline as given below.
Fine.
Yes. So, my Lord, 18 and 22 both are requirement. So it has to be signed by the assistant engineer and it has to be either again signed or countersigned by the assistant engineer, assistant executive engineer. Now kindly come to the, my Lord, minutes of the technical bid evaluation at page 213. What the writ petitioner respondent did, my Lord, he did not got it signed by assistant executive engineer or countersigned. That is how his bid was rejected.
213.
213, my Lord. Serial number 7 is the writ petitioner respondent and serial number 8 is the appellant.
Learned single judge held there should be harmonious.
That is that single judge relied upon a judgment that was in the context of a service rule, my Lord.
Simanta Gogoi.
Yes. Simanta Gogoi is the writ petitioner. Kindly see. Site plan not countersigned by the executive engineer, assistant executive engineer of PW.
Or violation of 22, 3 of bid document.
Yes.
What is this?
And another violation is violated point number 22.3 of the bid document. Actually, my Lord, they should not approach the members of the tender committee and all. Anyway, those were delegations are there, my Lord, that after submission of the tender, the writ petitioner respondent was trying to contact these people.
Influence them.
Anyway, that is not the point. We are
But
basically.
he was not named in the affidavit filed by the.
No.
That's why I have not pressed it also. Now, the learned single judge, if your lordship will kindly come to page number at page number 264, my lord. Para number 26. It starts at page 263, para 26, my lord.
On a careful reading.
On a careful reading of serial number 18 and 22 of the list of document, this court is of the view that there is no indication in the NIT that serial number 22 should supersede or prevail over serial number 18, read with annexure C. In Maya Matthew, this is a service matter, my lord. Supreme Court held that when there are two sets of rules, the court should endeavor to apply a harmonious construction to the said provision. Similarly, in this case, as the site plan can be certified under serial number 18 or 22 of the list of document by an assistant engineer and assistant executioner respectively, rejection of the petitioner's technical bid only on the ground that the petitioner's site plan had been signed by AE and not by is found to be arbitrary. Now, where is the question of harmonious construction, my lord? Had it been a case between 18 and 22, there is a or, then also things should have been different. Because the tender specifically says annexure C of the first document and additional requirement. So it's a simple case, my lord, in my humble submission, my lord, notice.
We accept notice on behalf of.
But I excise department, my lords, 2, 3, 4, 5 minutes. No, 2, 3, 5 minutes. This case.
2, 3,
And 5.
2, 3 and 5.
He's for number 4.
And you are appealing for? 4. 4. What
There's a
about,
private respondent.
what about 1?
Private respondent.
Writ
The
petitioner.
beneficiary of the order.
Mr. So-and-so accept notice on behalf of the 2, 3, 4, so-and-so and Mr. So-and-so. Let notices be issued to the respondent number 1 only. Returnable 4 weeks. Dusty and registered daily. Full stop. Taking into consideration the fact that the tender resolution committee has specifically recorded their finding that the appellant, that the respondent has failed to. Respondent number 1. Respondent number has failed to submit site plan duly signed by the assistant executive engineer as per the
Clause 22, my lord.
as per clause 22 of the bid document dated 23/2/2024. We deem it appropriate to stay impugn judgment passed by the learned single judge till next week.
Deep level.
All right.